Hello and welcome to episode 112 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Barron, the CCF's executive director. In today's episode, I'll tell you about the arrest of an Alberta man who refused to apologize to a librarian.
And I'll explain the concerns over a recent court decision that found the United Nations Declaration on the Rights of Indigenous People, UNDRIP, can now be used to interpret and even invalidate British Columbia laws.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about a poison pill that was included in the Federal Budget Implementation Act that poses a serious threat to the rule of law because it would allow ministers to exempt any individual or corporation from almost any law. That's right. So listeners will recall, I'm going to take you on a little bit of a history tour here. Back on January 6th of this year, Prime Minister Justin Trudeau informed us that he would ask the Governor General to prorogue Parliament until March 24th, so the Liberal Party could find a new leader. Governor General agreed, and MPs were sent packing for 3 months. We then get a new Prime Minister on March 9th, Mark Carney. He gets confirmed in the election on April 28th, but Parliament still doesn't resume until May 26th. So add in the Christmas break, and Parliament's been sidelined for 6 months at that point. Then we're told there's simply no time to do a budget, which is the main opportunity for parliamentarians to hold the executive to account. And instead, what we get is Bill C5, which allows the Carney government to pick projects of national interest and exempt them from all but a short list of Parliament's own laws. Then they go home for the summer, and we come back and finally get the budget November 4th. The Liberals narrowly survive a confidence vote on November 18th. And now, weeks later, we learn that the budget that they've passed includes this poison pill that would concentrate even more power in the Prime Minister and Cabinet than has already been concentrated in them over the last year. This is Section 12 of Bill C-15, which says that the Minister can exempt any individual, business, or other organization from any existing law or regulation other than the Criminal Code for up to 6 years with very few limits. This means Prime Minister Carney and his ministers will get to act like dictators, greenlighting exemptions to Parliament's laws for their friends and for corporations that they favor whenever they find it to be convenient. Section 12 says ministers would be allowed to create exemptions to any law as long as they assert a few things. They have to say it's in the public interest, that it would enable certain goals like testing a new regulatory regime aimed at innovation, competitiveness, or economic growth, whatever that means, have benefits that in their view outweigh the risks, and come with measures to protect health, safety, and the environment. But it's really all based on their own opinion, and we have to take their word for it because unlike most orders or regulations, which have to be published in the Canada Gazette within 30 days, the minister would only be required to notify the public as soon as feasible. And the minister would be allowed to keep information about their order, the order-making process, secret if they decide it would be inappropriate to make it public, which in my view allows them to do some pretty shady things. For example, they could enter into contracts with individuals in situations where doing so would, otherwise violate the Conflict of Interest Act and never tell us the details. It could mean citizens and journalists get blocked from seeking documents under the Access to Information Act and have no way to appeal that. It means mining companies might be able to avoid their obligations under the Extractive Sector Transparency Measures Act, which is aimed at preventing, bribery and corruption. And it would create all kinds of regulatory goodies for ministers to reward their preferred companies with by letting them avoid things like environmental regulations while their competitors still have to deal with the red tape. And to me, that really gets at the heart of the problem here, which is that other than the obvious risk of corruption that we might not find out about, it would also allow ministers to avoid the necessary work of convincing Parliament that certain laws are bad or too onerous and need to be amended. And there's no question there are lots of laws out there that are, standing in the way of progress or development, but the solution is for Parliament to fix the laws, to actually go to Ottawa and do the work of figuring out how best to do that. That's democracy. For example, rather than exempting preferred projects from the Impact Assessment Act, sometimes called the No More Pipelines Bill, why not work out how to fix that project review process so that all companies can compete on a level playing field while still protecting the environment and respecting Indigenous rights? As it stands, preferred companies will be able to avoid all of that red tape that the Impact Assessment Act creates, which requires all these assessments of intersectional gender impacts on building highways and things like that. And the cynic would suggest that they're doing it this way because Carney and his cabinet would rather give themselves the power of picking whose lucrative proposals move forward and whose don't than actually fixing what's broken. And I really hope that's not the case. But the important point is, in a democracy, ministers shouldn't be deciding that any individual or company gets a free pass from the law. That's really not that different from being ruled by a king or by a dictator. We send MPs to Ottawa to represent our interests by ensuring that laws are fair, necessary, and broadly representative of Canadians' needs. And by the way, we shouldn't forget this is a minority government that we sent to Ottawa. And I understand Parliament is probably going to pass this anyway. The Conservatives will be, tempted to pass this because nobody wants a Christmas election, except maybe the Bloc, since the Liberals are still polling pretty much where they were on election day. But they should think carefully about whether they want to slow this down and, try and get it excised, because it really is giving more power to the executive, which has already taken so much power from them in the last year by preventing Parliament from sitting and from not doing a budget in the spring. Joanna, I was thinking about this. Does this remind you of any other power grabs that the Liberal Party has done in recent years?
Yeah, well, where should we start? I mean, just in the last year, we had the prorogation for whatever you think about whether judges or judicial review have anything to do with it. The answer is no, but it was for purely partisan reasons, not to reset the agenda, but to give the Liberals time to install a new leader, sending home MPs for 3 months, following by on another lengthy delay, if I recall correctly. I tried to block it out before Parliament was recalled. So that's basically half a year without Parliament working. Then, once Carney was in his saddle, his government tells Canadians that there wasn't time to table a budget, which is, of course, Parliament's most important tool for holding the executive to account. And instead of a budget, they rushed through Bill C5, which gave Cabinet the power to demarcate national interest projects and shield them from parliamentary review and parliamentary statute. So the modus operandi of this government has really been governing by exemption rather than legislating. And even now, they're like pushing through this pressurized high stakes timeline for this budget vote. A minority government that is daring Parliament to defeat it right before the holidays. So it's kind of skirting the line of contempt of Parliament. And I'm really glad that you're bringing attention to this, because I think this is the type of the things that is easy. It's like it requires some breaking down, and it's easy to ignore it. But this is the piping. This is the wiring of our democracy. What do you think, Christine?
I mean, I don't have a whole lot to add. I think that those are all really important points. I don't know if this is a devil's advocate position on the prorogation, but honestly, I'm starting to feel like the less Parliament is sitting, the less damage they're doing. So maybe we want more of that. If we did,
is the alternative better? Is the alternative of just
I'm just pointing out the positives. Let's just find the silver lining.
Okay.
If they're not there, then they're not passing things like C9. They're not passing some of these terrible laws. So maybe I'm pro lengthy, undemocratic prorogation if it means less damage to other parts of our institutions and constitution. I mean, I don't think I really believe that, but I'm getting pretty depressed with some of the things that I'm seeing Parliament doing. But you know what? The courts are doing worse things. Maybe the courts are doing some pretty bad things. I'll talk about one of them now. So I'm going to talk about a decision out of British Columbia. It's a case called, I don't know, guys. you might have to correct me. I don't live in British Columbia, so I've actually never heard this name of this First Nation pronounced before. I think it's Gixtala. Am I saying it right? Do you guys know? Gixtala? It's spelled Gitxaala. So I apologize if I'm saying it wrong. That's how I'm going to have to say it because I actually just don't know. But it's an important decision. The case is called Gixtala and British Columbia Chief Gold Commissioner. And the case is about mineral legislation and mining rights, but it's actually more broadly, it's about UNDRIP. And the question is whether courts can use British Columbia's UNDRIP law, which is called DRIPA, or maybe in the future, potentially even the Fed's UNDRIP law to strike down or invalidate legislation. So let me explain what this means. British Columbia passed a law in 2019 called the Declaration on the Rights of Indigenous Peoples Act, DRIPA, and it's the first law in Canada to legally commit a government to aligning its laws with UNDRIP, the United Nations Declaration on the Rights of Indigenous People. Most of our listeners are probably familiar with what UNDRIP is, but in very simple terms, it's a United Nations standard for how governments should treat Indigenous people. And it says Indigenous people have a right to self-government, to their lands and resources, to their cultures and languages, to make decisions about matters affecting them, to be consulted, and in some cases give consent before major projects happen on their lands. Now, it is not a treaty and it's not automatically law, but some countries like Canada, like British Columbia, can choose to use it as a guide or pass legislation to try to align their laws with UNDRIP. So what does that mean in practice? Well, BC passed DRIPA, which is their kind of implementation of UNDRIP. And in the Gixtala case, some First Nations, the Gixtala and the Esat First Nations, challenged the province's chief gold commissioner over the province's automated online registry system that allowed prospecting claims for mineral rights on Crown land to be registered before a consultation with the affected First Nations. And the Gixtala argued that the system is inconsistent with the rights that are recognized in BC's DRIPA legislation. And they argued that if the mining law is inconsistent with DRIPA, it should be struck down. Now, this is a broad-ranging argument about the scope and effect of DRIPA. It would mean DRIPA applies not just to the mining statute, but to all BC laws, and that it is justiciable by the courts. And a court that thinks legislation is inconsistent with DRIPA could actually strike down that legislation, and that would have huge consequences. Now, the trial judge in the Gixtala case did not accept this argument. The trial judge said that courts cannot use DRIPA to strike down statutes. The trial judge found that the issue is non-justiciable and that the legislation is not enforceable that way, which, as I understand it, is how the government actually originally sold the legislation to the public. Professor Dwight Newman has written about this in a paper in Energy Regulation Quarterly. And he said that the trial judge's view is consistent with how the government talked about and debated the bill when it was proposed and finally passed. But of course, some people don't like this interpretation. They think DRIPA should apply broadly and allow courts to opine on whether or not legislation is valid if it's inconsistent with DRIPA. And they said it should empower the courts to strike down statute. And obviously, this was the position of the Gixtala, who appealed the trial court decision. And last Friday, the BC Court of Appeal released its decision in that case, and they accepted the Gixtala's argument on this issue. They expanded what DRIPA can do and found that it is justiciable and it can be used to strike down statutes. The majority in the appeal held that whether a BC statute is consistent with UNDRIP or DRIPA is justiciable, and that means that it's something the courts can decide, and that UNDRIP won't just apply to mineral rights legislation, as was an issue in this particular case, but to all British Columbia laws, which will have wide-ranging and unforeseen consequences. So, for example, right now, the BC government is working to secure tens of billions of dollars in new mining investments. Critical mineral mining is a huge centerpiece of BC's economic plan. And this Gixtala decision now throws huge economic uncertainty into BC's economy. And combined with the Cowichan decision that applied Aboriginal title to private fee simple land in Richmond, BC, courts are just creating huge instability in that province. Another possible consequence of the Gixtala decision is that it could be that UNDRIP now applies, or in the future would apply to federal statute. This is possible because the Trudeau government passed a federal version of DRIPA in 2021 in Bill C-15, the United Nations Declaration of the Rights of Indigenous Peoples Act. And it acts much like the BC legislation. So if BC's DRIPA legislation can now be interpreted to allow courts to invalidate statute, a court in the future might also interpret the federal UNDRIP legislation the same way. This would require more litigation to have that result, but it's a possible consequence. Now, the dissent in Gixtala did not agree with the majority approach. In a dissenting opinion, Justice Paul Riley argued that DRIPA gives legislators, not the courts, the mandate and responsibility to pursue legislative reconciliation through the implementation of UNDRIP. And that was basically what was held at the trial level. But that is the the dissent, and there is a totally different approach that's been taken to the majority by the majority. Now, what's going to happen next? I guess BC could appeal this decision, but they can also change the legislation, which is what they've already announced they're going to do. They announced this, the decision came out on Friday, and on Monday, the NDP government announced it's going to be amending DRIPA. Premier Eby told reporters clearly amendments are needed, and he said that the objective would be to make it clear that it is up to not the courts to bring provincial law in line with DRIPA. He said this is the territory of government negotiating with First Nations, setting the pace and choosing the laws to bring into alignment. So we don't yet know what these changes are going to look like, but I suspect they might also now be needed at the federal level to avoid a similar problem. So, I mean, combined with Cowichan, the courts in BC are really causing a lot of issues for Premier Eby. Josh, I'm interested between the two cases, Cowichan, which deals with Aboriginal title being applied to fee simple private property, and UNDRIP being able to invalidate provincial laws. Which one do you think is going to cause a bigger problem for British Columbia?
Well, that's an easy answer because Cowichan is based on Section 35, which is constitutional. And so what the court says the government has to follow. They can't just write a statute that overrides the Constitution. And Section 35 is not even a section that has a notwithstanding clause. Now, the court has said that it does have something like a notwithstanding clause, which is that you can justify infringements in a lot of cases. But obviously, if you're dealing with something that's just a statute like DRIPA saying we're going to incorporate international law and interpret our own statutes in accordance with this international law, well, they can end that any time. Like, it's only BC and the federal government, as far as I know, that have even said they're going to, follow DRIPA when they're making their own laws. So I think that statute can pretty easily be repealed. And I just want to say, like, I don't even know that I blame the courts here as much as I blame politicians, because they're the ones who created, Section 35 without actually figuring out what it's going to mean long term, and they also created this statute. Eby was, I believe, Attorney General when this statute was originally written. So now it's like, which guy did this? Oh wait, it was actually me. It was Eby himself who passed this law. So. Yeah, one last thing I'll say about that before I hand it over to Joanna. I just remember being in law school and these statutes were being proposed and debated, and the people who were in favor of them were saying, "Don't worry, this is all just symbolic. This
Exactly.
doesn't really matter. It just means when we write a new law, we'll think about UNDRIP and decide whether we want to, respect the things that UNDRIP says about free, prior, and informed consent, et cetera. But we're just doing this as like a nice symbolic reconciliation thing, but it's not really worked out that way. It turns
It
out
was
laws have meaning.
like massive gaslighting because I remember people raising at the time, like, you can say that, but the courts might interpret it as in a different way to make this actually enforceable that way, the way we're saying. And they're, oh no, you're crazy for thinking that. Like pure gaslighting. Lo and behold, I mean, just don't give the courts, these activist like courts, a tool like this because it's so predictable how they're going to use it. I remember that debate so well. Joanna, anything to add there?
That's a good point. That yeah, EB used to be in the seat that kind of facilitated this to happen. But I'm still going to give him credit for some leadership. Some leadership is better than no leadership. I'm really glad he's not hiding behind the judiciary, passing on the hot potato because God knows that this is a sensitive issue, particularly for British Columbia. I appreciate the clarity of saying that DRIPA was never meant to give the courts the power to strike down statutes, and that being very clear that this work belongs to elected governments working directly with First Nations. It could just be that nobody contemplated that it would get this far, right? Like nobody contemplated, Rupa Subramania, who's a friend of Josh's, had a great piece I was reading last night in the Free Press about Indian immigrants who came to Canada and sacrificed everything to buy a piece of property in Richmond that's now been in their family for 2 generations that are now being told, it might not be your property. It's just, nobody could have anticipated these things. And I think Tom Isaac, his point from the beginning has been that this is something that, it's creating a crisis of leadership fundamentally. So I'm going to give David Eby some credit because he certainly could have chosen many more cowardly options, and God knows that it's in his party's impulses to do so. So I was relieved to see this. So let's take a break, and when we come back, we'll talk about Derek Reimer. Okay, so before we get back into the podcast, I want to mention that our annual end of year Giving Tuesday matching fund is still ongoing. I'm really delighted to share that so far we have beat all of our previous year's records. We're doing extremely well. We're more than halfway towards our goal, but we still have lots of capacity to match your donations. 2026 is going to be a big year in many ways for the CCF. I guess Christine mentioned this in her email out to our list yesterday, but for those of you who aren't on the Freedom Update list, which you really should be, go to TheCCF.ca to sign up because we send out newsletters every week and we provide commentary and constitutional news of the week. But anyways, Christine announced, which I guess now I will announce very vulnerably to our podcast community, that my family and I are expecting twins in February, and I'm going to be stepping away, as you would expect, for about 8 months. And Christine is going to be taking over the organization. And it's a big year. We have all of these things going on in BC with land rights, not to mention the Emergencies Act case, which we expect we'll see major movement on in 2026. So if you want to support the CCF, now it's a great time. And thank you for considering it. You can go to TheCCF.ca/donate.
And I'm really excited for you and to step into this new role. It's such an amazing time for everybody.
Yeah. Okay, so we are going to Calgary to talk about some egregious free speech violations. This story should alarm anyone who cares about free expression, regardless of whether or not they agree with this individual's views or find them offensive. Pastor Derek Reimer has been arrested, not for what he said, but for refusing to say something that the state ordered him to say. And that's a clear line that liberal democracies are never supposed to cross. So Derek Reimer was arrested this past week after failing to comply with a court-ordered requirement to apologize to a public librarian. And this stems from a confrontation 2 years ago in 2023 at a Calgary public library during a reading with royalty drag queen story hour event. Seems to be a real flashpoint in Calgary. They're really into their drag queen story hours, and it seems to bring up a lot of polarization. In any event, Reimer objected to the event. He later posted the interaction with the librarian online, encouraged others to voice their disapproval. And as part of his sentence, a judge interpreted Reimer's comments as intimidating and ordered a formal apology to the librarian. Reimer refused to write the apology on the grounds that it would require him to admit wrongdoing that he denies. He was arrested for breaching that condition. And so this is, look, I don't want to get into drag queen story hour, LGBTQ inclusion, or religious conservatism and its dictates. It's really about the compelled speech. That's really the egregious issue here, as well as the expanding reach of the justice system into matters of conscience and speech. So, as we've talked about before on the podcast, compelled speech is considered an extreme measure, and the courts have continuously recognized limits on compelled speech for decades, from freedom not to salute the flag to professional speech cases. And ordering an individual to endorse a specific viewpoint through a forced apology goes beyond preventing harm. It requires ideological compliance. And I think Jordan Peterson's point with this back when everything blew up with him in 2016 was that compelling speech is proximate to compelling thought. So this, court-ordered apology is not restorative justice. It's not okay. Restorative justice requires voluntary engagement. This is like state-mandated contrition, and it's backed by the full sort of scope of tools the state has for refusing to comply with orders. So Reimer honored the no contact order. He honored the order from the court not to return to the library. And his breach is really that he did not author a letter whose content satisfied the court. So when the state imprisons someone, not for an act, but for a refusal to utter a prescribed phrase, it verges on authoritarian logic. The librarian, according to Reimer, never used the term intimidated. This is sort of a side point in her own evidence. She just said she was upset and anxious. She was concerned about reputational harm. And the judge took the liberty of interpreting her subjective emotional response to underwrite a compelled speech order. So once again, we're seeing a pattern where hurt feelings are becoming really grounds for criminal coercion. So this should worry anybody who cares about civil liberties. There's no limiting principle, and if a judge can order you to apologize for upsetting someone with your personal convictions, political, moral, religious, whatever they might be, that becomes a speech policing tool. And we see that this fits within a larger trend, increasingly expansive frameworks of what constitutes harm that can be considered for sanction, courts and tribunals venturing into tone policing, which we saw in the Jordan Peterson Ontario College of Psychologists case, and interpretations of speech, and a growing willingness to use as a condition of parole or release compelled speech. We saw this with another Alberta judge a few years back in a notorious case during the COVID era where two street pastors were forced to give a Surgeon General's warning before opining on COVID lockdown measures or the vaccine, which was also absurd and was ultimately overturned by the courts. So, Josh, I know that you have talked to some of CCF's lawyers in our network and donors about this. Anything to add about Mr. Reimer and this situation?
Yeah, I mean, I find the speech restriction concerning. He is considered by a lot of people in the Calgary area to be an unsavory character because he's, going after librarians, and I don't actually know all of the details here. when we talk about restrictions on free speech that are justified, those are justified if there's, genuine criminal intimidation, or if there's harassment, or if you're, physically using your body to stop somebody from speaking, whether it's drag queen story hour or anything else. So we have to sort of set all of that aside, and whatever he may have done or not done, it's not okay to order people to make apologies that when they don't believe the words that they're being compelled to say, and that's sort of the bottom line here. So people need to understand that while we don't condone, illegal activity like intimidation, harassment, those sorts of things, we draw the line at compelled speech. Christine, anything to add about this?
Yeah, I mean, I think compelled speech is one of the most totalitarian tools that exists. I think it's worse than censorship and censorship of opinion. But the idea that the government could come in and force a person to say certain words that they don't believe is completely evil. And this isn't your mom. Your mom can make you apologize and like teach you to be a good person. The government is not your mom. The government is much worse than your mom and doesn't know the difference between right and wrong in many cases. And the idea that we would empower these violent tools of the state of like potentially what's the consequence going to be if he says no? Like contempt of court? You're going to put this guy in jail?
He's been arrested. He has been jailed.
This is insane to me that you would put a person, take away their liberty because they refuse to apologize, to say words that the government has said they must say. I mean, this is real, like George Orwell type conduct by the state. Like we are just not supposed to do this in Canada. So I'm appalled, and anytime I hear one of these stories of compelled speech, whether it was the pastors during the pandemic or this, which seems worse because the pastors had that overturned. This is, I don't even know what to say. It's completely disgusting. It's worse than a bad legal take, Joanne. I'm glad you made it your headline. I'll turn now we'll talk about our bad legal takes now. I'm pretty worked up about this, this jailing the guy. So my bad legal take goes to Mohammed Fake or Faki. Do you guys, the names are killing me today. I don't know.
Both of those pronunciations were just 10 out of 10, like low key shading him.
I'm not
Mohammed Fake or Faki.
I'm not trying to shade. Like, I don't know how to say his name.
I know you weren't. Well, Freudian slip, I guess.
So Mr. Muhammad, so he's the chair of this Middle Eastern chain restaurant, Paramount Foods, which I actually used to go to. I used to really like it. There was one down on Yonge and Dundas that was really good. And then there's one there aren't as many locations anymore. There's one near my house, but I stopped going because I just thought that the quality kind of fell off a cliff, and I refused to eat dry shawarma. So I don't go anywhere anymore. But he also is quite the personality on Twitter. He has tweeted a lot since October 7th about the Israel-Hamas war. He really does not like Israel, which, he's entitled to his opinion. He's also opposed to Bill C-9, which, hey, so am I. I talk about C-9 all the time. I advocate for it to be withdrawn. I've written multiple op-eds about it. Yesterday, I spoke to about 900 Protestant faith leaders about why the Bloc Québécois amendment to C-9, which would remove this defense of good faith religious opinion, why that amendment is dangerous and a big problem. But let's be really clear. That amendment is coming from the Bloc. The Bloc asked every single witness about this religious defense to hate propaganda charges. The Bloc has been pushing for this amendment, not just in this bill, but they've been pushing for it for a long time. And the Liberals are seemingly willing to entertain the Bloc's amendment because they have a minority government and they need the support of the Bloc to pass the bill. So this amendment is about Quebec nationalist secularism, or I would dare to say religious hostility. It is not about Israel, but Mr. Muhammad has Israel derangement syndrome. Everything is Israel's fault. including, I guess, this amendment. He called it the Housefather Amendment. Housefather is the Jewish pro-Israel MP. He's one of the only Jewish pro-Israel MPs in Liberal caucus. And he is not the motivating force behind this amendment. It is not a Housefather amendment. It is a block amendment. And Mr. Mohammed Faik said that the bill was shaped by the pro-Israel lobby and it is aimed at Muslims and Palestinian voices. Um, the removal of the religious exemption actually has nothing to do with the quote pro-Israel lobby, which in my opinion could very well just be a code word. It's not really about pro-Israel, it might be about a different group. The overall bill was supported by some Jewish organizations, but not universally. I watched every witness appearance. A lot of Jewish organizations had issues with different part of the bill. And in fact, in response to the block amendment on removing the religious defense, a number of Jewish organizations put out a letter basically saying that they do not have a universal position, that they all take different positions, and many of them are either neutral on the amendment or don't support the amendment. So it's just absurd to say that this amendment is driven by the quote pro-Israel lobby, or that the government is controlled by the pro-Israel people. This is from the Bloc. The Bloc is not sympathetic to Israel or to Jews, and the Bloc was behind this. And I responded to Mr. Faik, Mohammed Faik, saying, I think that it is very weird and telling that that is who he chooses to blame. The bill is a problem, but it was led by the Bloc. Now, so I think bad legal take to him for this whole blaming of certain groups for this bill and for this amendment. I think it's gives a lot of insight into who he thinks is responsible for anything he doesn't agree with. And that I think is a problem. But the response, I wrote that. I said the bill is a problem, but the terrible faith amendment is very clearly led by the Bloc. Weird and telling that you somehow think it has anything to do with the quote pro-Israel lobby, as you call it. But the response to this tweet that I had just has me dead. A few people have replied to that post with a screenshot of me at a party hosted by CJ from 10 years ago with my friends. Now, I will give you the context for this photo. This was at that time where you could simultaneously post something on X and on Instagram. So this was like a double post aimed at Instagram. And it was also kind of a thirst trap because I was on a date at that event with the man I'm now married to when we first started dating. So I kind of posted this like cute pic of me with the caption "Blondes for Israel." So now people have reposted this saying like, "Oh, we got you." Like, "Oh yeah, you really got me posting a picture of me from 10 years ago where I look amazing. I'm so embarrassed. Keep it coming, guys. Like embarrass me more. I love it." Anyway, the whole thing is just really ridiculous. Fake's original take and then these responses to me. It's all just like bad takes across the board. But as a small update, the Faith Amendment did pass late last night, which is pretty depressing. And I'll also give a bad legal take to that amendment and to the whole bill. Joanna, how about you? What's your bad legal take this week?
So my bad legal take goes to the University of Victoria. This is another egregious free speech thing. Francis Widdowson, who is a Canadian academic, showed up on campus last week or the week before for an event organized by the OneBC party. And UVic had sent her a letter the day before saying that she was not permitted to attend UVic property for the purpose of speaking publicly. Yes, that is an actual sentence from a Canadian university. So Widdowson arrived anyways. Campus security and Saanich police served her a trespass notice and arrested her under the BC Trespass Act, which can carry fines or even jail time. Meanwhile, nearly 900 protesters had gathered. Emotions were running high. Smoke bombs appeared on campus. And the university's response was not to open space for debate about clearly controversial issues, which we'll get to in a moment, not to ensure safety for everyone, but to declare that the speaker herself, who, by the way, is a former professor at UVic itself, was now a legal intruder. Now, Frances Widdowson writes a lot about residential schools and writes about the so-called graves that, as many journalists have reported on, there hasn't been any compelling evidence about. Obviously very inflammatory for a lot of people. People have accused her of being a residential school denialist, but you don't need to agree with her views. You can disagree with them. You can find them offensive. You can find them misguided. That's not the issue. The issue is that universities are supposed to be dedicated to mooting out these very contested, sensitive issues, and they're supposed to be dedicated to free expression. And UVic has shown that it's so dedicated to free expression that it will arrest you for trying to express something on their own campus, because nothing says hub of open inquiry and intellectual exploration quite like cops storming a campus, escorting an academic away for merely attempting to speak in a public outdoor space at the institution where she earned her degree. And if UVic's position is that controversial ideas must not be met with argument and counter-argument, but with trespass charges, it's not protecting vulnerable students. It's protecting itself. It's insulating itself from the discomfort of intellectual disagreement and pluralism. And that is far more dangerous than any single talk Frances Widdowson might give, which, by the way, on cue, she's obviously been, her profile has been elevated once again, and she's been made into a martyr for this incident. Josh, what's your bad legal take?
My bad legal take goes to the head of court services in Newfoundland and Labrador, who decided to cancel all civil trials and other matters like traffic court in multiple courthouses until further notice and without much explanation. So for those who haven't been following this story, it's pretty unreal. You know, people just show up at court and it's like, oh, it's closed, no court happening. We'll reach out to you when we feel like it. Apparently, this is because staffing is bad, but the bad legal take here is really that anyone thinks it's appropriate to do this so suddenly and without explanation, considering its impact on the rule of law. You know, I can understand being somewhat light-staffed, like, you know, people get the flu or whatever, but justice delayed is justice denied, and you know, you can't just do this without any explanation for a significant period of time. I don't know about the particular situation with staffing in Newfoundland, but I will say court services here in Ontario is, you know, always complaining that they're understaffed, and I don't know that that's actually true. And I think a lot of provinces need to take a serious look at whether, for example, security guards are needed in every single courtroom when you could, you know, use a roving team and have good screening at the door. And registrar is a very important job, but are they doing things the most efficiently? I mean, I had some emails this week, you know, where we just needed a very simple answer to a very simple question, and it took several emails. So they could be a little bit more efficient. And, you know, why are we still using human translators and court reporters for everything when you could use, you know, fewer humans aided by AI? So long story short, there are solutions here to these problems, and nobody should be unilaterally closing down courthouses for a long period of time without much explanation. And so I hope the government in Newfoundland takes this seriously and takes a hard look at how they can make sure it doesn't happen again. All right, so that's the end of the show. As usual, we will ask you to rate us, review us, and subscribe if you haven't already, and you can support our work by visiting our YouTube channel, by signing up for the Freedom Update newsletter, and by donating at TheCCF.ca. And of course, as Joanna mentioned, those donations will be matched up to $125,000, meaning we could get a $250,000 head start on our work for next year. Thanks for listening.